is so obvious and so blatant, it was so obvious that this should have been produced. And so, this is my term, just blatant in the refusal to provide it, that I think it's rare for us to do this, but some monetary fine is warranted.
And they made public policy arguments. To me, the countervailing public policy argument is that people have a right to know whether their bridges and roads are safe. And to me, that is prevailing public policy or body camera video that she's asking for here in this instance, in this case, is an investigative report.
This feels like trying to shoehorn something into the investigative report exception. I think most citizens assume that most law enforcement officers now have body cam that's either activated by voice or always on, or that's our assumption, whether it's accurate or not.
Yeah.
So that doesn't feel like an investigative tool to me. It feels more like a sunshine tool for the protection of the officer, for the protection of the potential defendant, for the protection of the public. And when I started this, I wanted the result to be that they had to be produced as public record. So help me think through that.
This isn't some free will state, man. This is how it is in the state of Mississippi.
Yes.
I do it.
Hey, Aaron, can you hear us?
I can. Good morning.
Great. Good morning. How are you?
Good. I'm good.
Good. Thanks for being here.
Yeah.
All right, Mr. Chairman, we have a quorum.
Okay, right?
Yes, sir.
Oh, okay. Oh, I'm sorry. Okay, I call the meeting to order today. The first thing, we do have a quorum.
Yes, sir, we do. Aaron's on Zoom and we have 6 here in the room.
Tom, would you lead us with a prayer here?
Yes, sir, Mr. Chairman. Lord, we thank you for this day, for the opportunity to serve our fellow citizens. We ask for wisdom and discernment in the decisions we're called upon to make today. Amen.
Thank you very much. First order of business is the approval of minutes. Has everyone had an opportunity to take a look at these? Are there any corrections or additions? Hearing none, do I hear a motion that we approve them as written?
Move to accept the minutes as written.
I'll say.
Motion made and second, we approve them as written. All in favor, say aye.
Aye.
Opposed, no. The ayes have it. They've been adopted. Tom, would you give us kind of an update on the budget here?
Yes, sir, Mr. Chairman. We're 50% through the year and we have 52% of our money left. So we're still in the black. As y'all probably know, we get a lump sum appropriation from the general fund every year and we have to make that last 12 months. So we're on sort of on schedule and on par with that.
Okay, good.
Tom, I just had a quick question. I know we still have a ways to go before there's a deadline for appropriations bills. Any thought or any effort or any consideration on whether or not we could see an increase?
I don't have any prediction yet. Our first subcommittee hearing, our House Appropriations Subcommittee hearing is Monday afternoon. The Senate Subcommittee hearing is Thursday afternoon. I can, maybe report something after that, but usually I don't really know much after those. But we've got the same 3 requests that we had last year, an increase in salaries to bring us up to the SBB projections from several years ago. Money for a contract with ITS to build an SEI database, online database. And I'm blanking on the third one. It was a much smaller request, maybe for health insurance premiums.
All right. Thank you.
Good, thank you. And by the way, anyone's welcome. There's not any mandatory stuff to go to either one of those hearings. I plan to be at both of them. So, being back in Jackson here. Right? Okay, so next business is C.
Yes, sir, Mr. Chairman. Item C would normally be the legislative report, but the legislature just convened on Tuesday, so there's no bills to report yet. I just provided the timetable at next month's meeting. Certainly I'll have some bills to report. I think the 19th is the deadline for introducing bills this session. So we should know in a couple of weeks.
Okay, all right, let's go to item D, which is the open meetings act, and I think Sonia.
Yes, sir, Mr. Chairman. Sonia could not be with us today, but she asked me to present her cases, and I'll do my best with these. This one is involving a tree committee. I know they have those on the coast. I don't know if they have them anywhere else, and I don't think we've ever dealt with one before. It's interesting to me that this complaint was filed by a member of the tree committee, alleging that they didn't properly call their special meeting. It turns out they've never adopted rules about the times, places, and procedures for their regular meetings. They also did not post special notice of this special called meeting. Both of those are violations, and that is the recommendation here is to find that they violate the law both of those ways.
Right, you've heard the recommendation. Is there any questions, Tom, discussion? Not, do I hear a motion?
Make a motion to accept the staff report and recommendation.
Do I hear a second?
Second.
Motion made and seconded. We have approved the staff recommendation. Start. Any further discussion? Hearing none, all in favor say aye.
Aye.
Opposed, no. The ayes have it. Go to number, y'all have to excuse me, I can't see very well. 0111.
Yes, Mr. Chairman. Item E is another open meetings case that Sonia handled. This one involving the Oktibbeha County Board of Supervisors. This one's fairly simple as well. The board failed to make their agenda materials available at the time of the meeting. There's no requirement, as we've found in previous cases, no requirement that they have a copy for every single person that shows up. No requirement that they provide copies of any materials that they didn't have time to copy. But there is at least a basic requirement that they have their agenda materials available for the public to look at during the meeting. We've said you could do that by projecting them on a screen, as we're doing here, or with a public copy. We do that downstairs. A lot of other boards do that, but you got to somehow provide access to the public to your agenda materials, and they just failed to do that at this one particular meeting.
Okay, you've heard the recommendation of the staff here. Are there any discussions or questions with Tom? Hearing none, do I have a motion?
Move to accept staff recommendation.
Is that second?
Second.
Motion made and seconded. We approve the staff recommendation. Is there any further discussion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Let's have it. Item number F.
Mr. Chairman, item F is a public records case that Sonia had presented, I believe, last month or at a previous meeting. She presented a preliminary report and recommendation. The respondent here, Department of Marine Resources, filed a request for reconsideration. That request is addressed in paragraphs, I think beginning in mostly in paragraph 2.21. This is as y'all may recall, a fairly lengthy recommendations, but the newest part of it is in this paragraph here, 2.21. The dispute here is really about the addresses of oyster reef leaseholders. Part of the request was information related to oyster reef leases, and some of that information included the applicants or the leaseholders' addresses. DMR wanted to withhold those because it's personal information, I think is the way they characterized it. There are statutes in Mississippi that do exempt certain classes of individuals, but generally people's addresses are not exempt. The real hurdle for them to clear is a case that came up in the early 80s. I think it was 83. It was during the Lally administration. Jim Roberts was DPS commissioner. and it was a request for the driver's license database. And the court said you got to provide those along with the addresses of everybody who has a driver's license. So that's a pretty high standard to clear, since there's nothing specific about in the law about these leaseholders' addresses. There's no exemption, and the default, of course, in the Public Records Act is if there's not an explicit exemption, then you got to provide it. And that's the basis for this recommendation.
You've heard the recommendation of the staff. Are there any questions or?
I do have a question. if I may, Mr.
Okay.
Chairman. This is page 8 of the report, which is page 51 of the larger PDF document. Very bottom, paragraph 2.14,
Mhm.
next to last sentence.
Okay.
It was highly irregular and improper. I don't disagree with Sonia's legal or factual conclusions about this.
Okay.
This overall case, that is to say. And even if what I'm about to suggest is not done, I'm going to vote in favor of this report. But I believe that we should remove that next to last sentence. It was highly irregular and improper for the agency director to voluntarily engage. That next sentence is certainly right. It did confuse everything, but I don't believe it's appropriate for it to be deemed improper, because I read the facts to be that the executive director was sort of going above and beyond to try to be cooperative with the inquiring citizens. So I'd like to see that sentence removed.
You make a motion to that effect?
Yes, sir.
Okay. Is there a second?
Second.
Motion made and seconded. We make that change. Is there a discussion? Yes. Hearing none. All in favor, say aye.
Aye.
All opposed, no. The amendment is adopted.
Thank you.
Do we have a motion on the
Make a motion to accept final report of recommendation.
as amended? Yeah.
As amended, yeah.
Okay, motion made and seconded. We accept final report as amended. Any further discussion? Here none. All in favor, say aye. Opposed, no. The ayes have it. This has been adopted. Let's go to item number G. I believe Rolf, you did this.
Yeah, thank you, Mr. Chairman. Commissioners, this is pretty straightforward. This is a complaining at South Delta School District. The requester requests a copy of the receipt confirming payment on 216 section leases to the school district. The complaint states he did a verbal request and then submitted a formal request, which was denied on all accounts. In its response, the school district cites their district policy, or they included their district policy, public access procedures, and pretty much verbatim in their response, they claim that these are financial records. And again, relying on 2561.9.1A, which would be records furnished by third parties containing trade secrets, as well as 7923.11, commercial and financial information of a proprietary nature. In their response, they did not cite anything other than stating these are financial records because we say they're financial records. So the conclusion right there in 2.4 states the receipt created by a public body showing the payment of rent for public property is it's definitely a public record and is in no way exempt from disclosure. So hearing officer recommendations, the commission find that the district violated 2561.5 of the Public Records Act by failing to provide responsive documents to the requester. Commission should order the district to provide Mr. Hatch with those responsive documents within 7 days of a final order being issued, and that they should comply with the Public Records Act moving forward. And I can answer any questions y'all have on that.
You've heard the recommendation of the staff here. Are there any questions that are discussing from Ross?
Mr. Chairman,
Yeah.
Ross, in section 1.1, I was a little confused in reading it. I had to go back sort of in the middle where you quote what the request is. It wasn't obvious that you were talking about a receipt of payment. And at first I thought it was a receipt of the lease versus a receipt of the payment. Is there any indication in the request or some verbiage which could be added, even if it's in a bracket, simply saying a copy of receipt of payment of these section 16 leases?
I went back and tried to clear that up. I guess, like I said, formal record request of information requesting a copy of receipts confirming payment of the leases.
Okay, all right, thank you. And then the second thing is, and this is maybe more for the commission in general, that this struck me as so obvious and so blatant, it was so obvious that this should have been produced, and so, this is my term, just blatant in the refusal to provide it, that I think it's rare for us to do this, but some monetary fine is warranted. I mean, even if it's, fairly small, a couple of $100s, I don't find any basis to refuse this document and have to think that, I don't want to say there was an ulterior motive or whatnot, but there's just no justification. This wasn't even to me, a good faith mistake on somebody's part. I don't know if you have any thoughts or comments about that.
I don't disagree whatsoever. I think we could amend the preliminary report and recommendation to include a fine of.
Mr. Chairman, I'd like to make a motion to amend the preliminary report and recommendation to add that we could do it as section 3.4 that would add a monetary fine of $300.
$300.
Well,
I have a question.
I think,
Is it up to 100? I can't. Is it? Okay.
100 max for a fine.
For a fine. Okay.
Their
I'm sorry.
cost.
Okay. I'm thinking.
Now, the Open Meetings Act is more, yeah.
Okay. Thank you. Thanks for the correction. So I'll modify my motion to make it $100.
Steve, I think, can we, rather than 3.4, amend 3.3, because 3.3 states that there's no penalty.
Okay. All right. That's,
did you amend your motion?
yes, I do.
Yeah.
Okay.
To modify it 3.3 that, basically adding that a fine of $100 would be added and that further violations may result in the imposition of additional penalties.
All right, you've heard the motion. Is there a second?
A second.
A motion made and seconded, we amend to, have a fine of $100. Any, what?
Question.
Yeah, sure. So,
Who are we finding?
Find the superintendent.
Is that, what does the Public Records Act allow us to do? Can we find the governmental entity?
No. Well, we did once, it says person, and a governmental entity is defined in another statute to include a person. So in other words, a governmental entity can be a person. So yeah, I think you can do it that way,
There's open sentence says the complaint was against the school district.
Yeah.
which is appropriate.
You okay with that?
Oh, yeah.
All right.
yeah,
Superintendent, oh, I'm sorry.
No, I appreciate you raising that.
Is the superintendent still the superintendent?
I believe so. I think I looked that up as I was writing this up. My understanding.
So Chris, your concern is can we actually find the school, the public body?
My recollection is that was a little more difficult but also that the Public Records Act contemplated finding individuals, even though they're government employees.
Yeah.
Yeah.
Originally, we could only file the governmental entity, and we got the law changed so that we could find individuals. But we've had at least one case where we felt like it was appropriate to find the public body and not an individual. But that's why I say I think it can be done, but it was not the intent of that amendment but it gave us discretion, I think, to do either.
so would you like to redraft your motion?
I guess to the current version of 3.3, if we're going to do the school district, I don't know if any
Okay,
further amendments needed.
that'd be fine. Okay, you've heard the motion and I believe we have a second. Is that
Yes, sir.
right?
Yes.
I have another question, Mr. Chairman.
Sure. Oh, absolutely. I'm sorry.
Is there any indication whatsoever about whether there was a receipt or what might have been on the receipt, like bank account numbers or any kind of personal identifying information of people that have the?
They acknowledged that a receipt did exist. They didn't go into any detail about what was on it, but they did say, we can't give that to you because it contains financial
It
information.
says sensitive, but they didn't describe what's sensitive. I
They
mean,
did not.
Use a quote. I guess that's something they said in a response or something.
We could always do an in-camera review if the commission wanted to do that.
I just, if we don't know what's in it and we tell them you gotta produce it, or they about to produce something that might have
Right,
something
there,
in it.
If their
Assuming
lawyer,
they
had-
have a receipt of some
if their
sort.
lawyer had been involved in this, I would feel a little more comfortable with that. But
yeah, they stated nothing other than, the requested information cannot be disclosed due to legal and ethical obligations to protect sensitive information.
So your point is that we probably should inquire as to that.
I don't know if there's a way to put a sentence in, but I don't want to encourage them to stir up worse. Pardon my,
Yeah.
ineloquent words. But, I do worry that if they were dumb enough to say sensitive information and there isn't any, if there is sensitive information on the receipt, are they going to take the time and care? I guess I'll try to use better words,
Yeah.
to make sure they're not producing a social security number or something else that it might.
yeah, maybe we ought to help them with that by getting the document and
Bank
looking
account
at it.
number, checks that have routing numbers on them, but
Mhm.
I don't know that there'd be any harm in that, but if they're turning over that information, it could have some confidential information in it. They should have redacted.
Okay.
Still produce a receipt, but redact any bank account numbers or.
Yeah, their response, and again, the response was submitted by the superintendent. It does name who their attorney is, so I think as a practical matter, we could maybe try to make sure that this ends up in the hands of their attorney to head that off.
What do you think about in-camera review?
And it is a preliminary report too. It's not a final report. So they could, in theory, come back and say, oh, by the way, there's this additional information over here.
That's why I said if their lawyer was involved, I would expect that to happen.
Yeah.
But if they're not gonna take this to the lawyer, then Chris's concern, I think, is more valid.
So at this point, then we may lay this on the table, subject to, or you do any work.
Yeah, I think
In-camera.
we might want, I don't want to speak for you,
No,
but
no.
I think we might want a little more guidance from the
Okay.
commission other than just,
That motion would be proper at this point. Like to make it.
I'll make that motion.
Motion made that we lay this on the table, so,
With apologies to.
is there a second?
Second.
Second, okay. All right, yeah. The motion is that we lay this on the table, subject to call. Is there any discussion?
Just one point, if I may, Mr. Chairman, I guess it's implied, Ross, by the motion itself, but maybe the easy thing to do is just ask them for copies of whatever the receipts are.
Yes, sir.
And then you yourself look at them.
Yeah, and that's what we normally do on that.
Yeah, we'll leave that up.
yeah, we have, just to clarify for anybody that might not have seen it, we have statutory authority to order in-camera review of disputed records. We do not have authority to get those records and then turn them over to the complainant. Because what if we're wrong and a judge disagrees? The cat's out of the barn.
Horse out of the
The horse is out of the barn. I'm a little bit impaired today, Mr. Chairman, from due to mental distress last night. Anyway, yeah, we don't do that. We don't turn them over, but we could order the school. You know, in other words, we get the documents, decide that they're not exempt, and then give them back to the school and say, we hereby order you to turn these over.
Okay.
Sorry if I
All right,
belabored
any
that.
further discussion? All right, all in favor, say aye. All in favor, laying it on the table, say aye.
Aye.
All opposed, no. Ayes have it, lays on the table, subject to call. All right, and the next matter, I think, is yours, Tom, is that right?
Yes, yes, sir, Mr. Chairman. This is, let me get to it over here. Do my other job for a second here.
Good point.
H is a case that I presented last month, and this is involving Department of Transportation. MDOT filed a request for reconsideration. This is the final report. It is exactly like the preliminary report, except that I addressed their request for reconsideration in paragraphs 2.6 through 2.8. Let's see, which is right here. The issue here was a bridge inspection report. There's a federal statute that exempts reports like that from discovery and evidence in cases where somebody is alleging a lawsuit where somebody's alleging that they were hurt on a public thoroughfare. They can't get that bridge inspection report and use it in evidence. The federal statute doesn't say anything about the Mississippi Public Records Act or any other state transparency law. In my view, it's limited to the things that are named in the statute, discovery and evidence. In asking for reconsideration, MDOT basically raised three points. They argue, and Sam mentioned this at the last meeting we talked about this, who's a construction litigator, so he had a very valuable perspective. But MDOT argued that litigants might obtain the records through public records request, either directly or indirectly, and it might enhance their litigation strategy and give them an unfair advantage. In my view, that's a discovery issue that belongs to the judge in that lawsuit. In other words, if I'm representing the highway folks, if the city, state, whoever, county, I'm representing that highway authority, and I think the party opponent, the plaintiff, has gotten that information through a public records request, then I think my job to go to the judge and say, Judge, they've done an end around, and you got to stop them from doing this. I think that's the judge's prerogative, not really ours, not really a public records issue. Second, they argued that releasing these reports under the Public Records Act would have a chilling effect on the people who write those reports. There is an exemption under federal law that I've had to look at before called the deliberative process privilege. Basically, if, let's say, Ross and I worked at a federal agency and we are working together on drafting a rule, our drafts would be exempt under the deliberative process privilege. And the rationale there is that we're not going to be as candid if we know that our drafts are going to get out in the public. Federal courts in Mississippi have looked at least twice at that and have said that doesn't apply to the Mississippi Public Records Act. And I cited those cases in here. So that's the way I address that. And then finally, they say the Public Records Act and Section 407, the federal statute, have to be read together. And I totally agree with that. But when you read them together, the federal statute does not specifically declare these documents exempt from the Public Records Act, which is what the Public Records Act requires. So I think that leaves us where I am, which is that I think the federal statute just does not go as far as MDOT would like it to. And I think we have to find that they should have turned over the records in order them to do that.
All right. Any questions or discussion from Tom?
I had a quick question.
Yeah, go right ahead.
I'm sorry. They talked about the Office of State Aid Road Construction talked about the deliberative process privilege and also worrying about somebody using it in strategy. And I think we had a pretty good conversation about that last time.
Mhm.
We've already discussed some of that. I was on the fence, of course, on this entire case. Did they make any argument that somehow them producing it through a public records request results in them waiving whatever privilege they have on the other side?
I don't think so. I don't recall them using the word waiver or even raising that concept. And they didn't describe it as deliberative process privilege. I don't think they even used the word privilege. I'm the one that latched onto that. That was my way of dealing with their argument. I'm not trying to be tricky or anything. It's just, quacks like a duck. I mean, what they were arguing was essentially deliberative process privilege, even though they didn't argue, they didn't use that term.
They didn't use the word waiver.
I don't recall them using that word.
I'd worry if they could waive it, that somehow producing it voluntarily waives it in some other thing. But I don't know if that's our issue, but especially if they didn't argue it, I don't know, it's something we should go invent for them to.
And to me, the way the statute operates, it bars the plaintiff from obtaining or using the information in the lawsuit. So you don't waive it even if you did waive it, right? Even if you did waive it, the judge could still say that's not admissible under the statute.
Yeah, I read it as a competence of the material as evidence as opposed to a privilege, but I do understand your point, Commissioner.
Yeah, I think that's correct. And this gives me a lot of concern too, but I think we're correct here. And that you get it one way, but you can't put it into the case.
Yeah. And they may,
the simplest way to put it.
And they made public policy arguments. To me, the countervailing public policy argument is that people have a right to know whether their bridges and roads are safe. And to me, that is a prevailing
That's
public
the heart of
policy
the
argument.
reporter's reason for the request, and I'm sensitive to it.
I agree.
That's right.
And so there's got to be some sort of balance there. And I understand MDOT's perspective, and I think they've done a good job of trying to argue their case. I just think that the law doesn't give them the tool that they need.
I think whoever drafted the federal statute, should have put in more than that. And I think probably they proved the day that they didn't.
Maybe so.
Yep, okay. All right, is there further discussion? Not, do I hear any motion?
Move to approve the final report and recommendation, Mr. Chair.
Okay, motion's made, is there a second?
Second.
Made and seconded, we approve the final recommendation, as submitted. Any further discussion? Hearing none, all in favor, say aye.
Aye.
All opposed, no. The ayes have it. Adopted. Let's go to number I.
Yes, sir, Mr. Chairman. Item I is Cage versus City of Centreville Police Department. This was, sorry, let me go do this. This case is very straightforward. This requester asked for a police report that is an investigative report about a juvenile offender who was charged in youth court, and it is exempt under the youth court law. We've looked at one or two cases that were almost exactly like that. This is no different. Youth court records are exempt. So there's sort of double exemption here. It's an investigative report and it's a youth court record.
Heard the recommendation of staff. Are there any questions of Tom? Any discussion?
Mr. Chairman, just more of an observation than anything. Tom and I had a discussion about this very issue, 2.3. There's a reference to an AG opinion. And my point is more philosophical. It has absolutely nothing to do with the Attorney General, but I'm loath to rely, I guess, almost upon authority, an AG opinion when it's our body, which is the charged with enforcing the Public Records Act and the Open Meetings Act. I'm not saying delete it. I thought the youth court law was the slam dunk. I think it's clear as day for there. But I just wanted to point that out. We'd had that conversation about with the way Tom explained it to me, and Tom, I don't put words in your mouth, but at one point early on in the process, maybe decades ago, there wasn't a whole lot of authority internally for us, but as far as Public Records Act of this particular situation, but now I think we do have plenty of authority, and I thought that the youth court law was just real clear about it. So I don't want to give someone who may be reading this years down the line some false assurance. Well, if the AG says this, well, then the Ethics Commission is going to follow that. And while we tend to be on the same page with the AG office, I'm just, like I said, I'm a little concerned about relying upon that as even a hint of authority.
Yeah, I didn't see that as necessarily relying on that, citing it in addition to what we were doing.
And Mr. Chairman, that's why I'm not asking it to be deleted. I think it is persuasive, but I just wanted to make that note. It's getting close, but you're right. It's persuasive here.
Okay.
Yeah.
Okay. Any further discussion? Okay. Do I hear a motion?
Mr. Chairman, I move that we accept the staff recommendation.
Okay. Second. Do we have a second?
Second.
Motion made and second. We accept the staff recommendation in this matter. Any further discussion? Hearing none, all in favor say aye. All opposed, no. The ayes have it, and it's been adopted. Let's go to item J. And this is for you, Sonia, as Vice Chair.
Yes, sir, Mr. Chairman. This is another recommendation from Sonia. This is involving the Pearl Police Department. This requester asked the police department for body camera video. If I remember correctly, it involved his own arrest or was related to his own charges against this person. So there's implication here that he's sort of using the Public Records Act to conduct criminal discovery, which we said over and over again is not a good idea. You have more rights as a defendant in the discovery process. You can get more documents than you can under the Public Records Act. But nevertheless, we address his request. The body camera video that she's asking for here in this instance, in this case, is an investigative report. Doesn't mean all body camera video is an investigative report, which is the problem with dealing with body cam video. They're all different. Every video is going to depict different things. There could be multiple exemptions that might apply to a single video. Other videos may not be exempt at all. In this case, it's evidence against this individual, apparently, and so it is an investigative report. He might be able to obtain it in discovery, but not through the Public Records Act. He also asked for a recording of the E911 call that led to this police response. E911 calls, records about E911 calls, recordings in particular, are totally exempt. You can't get them without a court order. So she's recommending dismissal of this complaint on those two bases.
Okay, you've heard the recommendation of staff. Any questions?
I have a few, if I may, Mr. Chairman.
Okay.
Have we rendered decisions regarding requests for body cam data
Yes,
before?
we have.
And have we fallen on both sides of the question?
I think we have. I got this question from a city clerk the other day, a general question about body cam video, and I didn't go read all the cases, but I very quickly found that we had 7 cases that deal with body cam video, and I sent her those to look at and told her to get back with me if she had any questions. And I think we have come down kind of all over the place because the videos are all over the place.
If you can think of examples, I'm very much interested because this feels like trying to shoehorn something into the investigative report exception. I think most citizens assume that most law enforcement officers now have body cam that's either activated by voice or always on, or that's our assumption, whether it's accurate or not.
Yeah.
So that doesn't feel like an investigative tool to me. It feels more like a sunshine tool for the protection of the officer, for the protection of the potential defendant, for the protection of the public. And when I started this, I wanted the result to be that they had to be produced as public record. So help me think through that.
You're right. The primary use of them is to protect the officer, to show what actually happened. If the officer didn't do anything wrong, then it's going to tend to vindicate the officer's conduct. That's why law enforcement agencies obtain them. I told Stephen the other day, I told this clerk the other day, I'm speaking next week to the Chiefs Association. I speak to them for 3 hours every year, and I preach on this. Every time you press record, you're creating a public record. They never think of it that way. Law enforcement do not think about the Public Records Act generally, and certainly not when they're responding to a call and recording their activities. And they are recording reams and reams of records, right? Whatever their camera sees is what they're recording. In this case, it's apparently evidence of a crime. I don't know what the background was here, and I don't go, whether it's Ross or Sonia, I don't go back behind them and look in the file and second guess. So I didn't go to the extent of trying to figure that out. But the police department's contention here is that that this is, evidence in its case, and its investigative report. It's not an incident report, which is the only thing in the law enforcement part of the Public Records Act that's explicitly public. Some of the things we dealt with on body camera footage, I think the last youth court record we had was body camera footage of response to an incident involving a juvenile. And I think the requester was the parent of the defendant. But they can't get the youth court records either without a court order.
That I understand.
Yeah, so we denied it or dismissed it on that basis. You can think of all sorts of hypothetical things that a video would pick up when a law enforcement officer shows up to a domestic situation. There could be a victim who's been beaten up and bloody. That's going to be exempt. It's a victim record involving a victim. Children, if it depicts a child who's we can all think, I'm not gonna go into detail, we can all think up of situations where a child in those circumstances is distraught and should not be shown on the nightly news. That kind of video would be exempt. The practical problem that goes with that is, how do you redact it? This clerk that contacted me the other day was in a very large municipality with a very large police department, and they don't know how to redact the video, because when they buy it, they don't ask the salesman, hey, what happens when somebody makes a public records request for this? How do we redact the victim or the child or whatever? Nobody thinks about that. And a lot of departments don't know how to redact. And those are the problems they run into. Those are the problems that the public records problems that body cameras create, that nobody's really thinking about except the ethics guy who worries about how you're going to deal with that.
Yes, sir.
I want to kind of not parrot, but echo what Andy said. My default is, yes, you're creating a lot of public records here, and I'm concerned with the police department's request or response that basically, if it's not an incident, it doesn't meet the definition of an incident report, therefore it's an investigative report. I don't agree with that. But I do acknowledge the investigative report exception is broad, and we are told by the legislature to construe it broadly, unlike all the other exceptions we've talked about here today. I guess my concern goes back to where unlike some of the other cases that you sent to me where we've looked at body cam footage, we're not even looking at the body cam footage here. We haven't even seen it yet. And so I think if we're going to do this on a case by case basis, which unfortunately I think is the only way to do this, it's going to be almost impossible to come up with a bright line rule. I think that we need to be able to look at that video and at least say, okay, either it's all protected by the investigative privilege after an in-camera review, or there's some portion of it that's not. None of us know, because we're kind of shooting in the blind here. So what I would like to do, Mr. Chairman, is to make a motion to table this for the purpose of requesting that the police department provide the video that's being sought for review by the hearing officer.
Is there a second to that motion?
I'll second that, and I have a
Okay.
question about it.
But that motion is priority. Motion made and seconded that we lay this on the table, subject to call, and ask the staff to further investigate. Any discussion of this? Not. All in favor, say aye.
It's fine, I can ask my question after we vote.
Okay.
I vote aye.
All right. All opposed, no. Ayes have it. But, can I ask a
If I may,
question?
Mr. Chairman.
One that now will be fine.
Thank you. Do we typically take a legislative agenda to the legislature?
Not every year.
Do we have anything pending this year that we've
No,
asked for?
We're not making any proposals this year.
And I don't want to do this just on the fly, but something to think about is to ask the legislature to declare public policy specifically with respect to body cam, because virtually every law enforcement agency in the state uses it.
That is part of my plea to the police chiefs every year for years now. I think that's the appropriate, not that we shouldn't do that or that we can't do that. We certainly can. It's our problem, right? We got skin in the game, but
But the police chiefs have never made that ask. Well,
I had hoped that they would initiate that, and
I don't want to bog us down, but it's at least something to think about.
yeah, I agree. It's our problem. It gets dumped in our lap.
Thank you, Mr. Chairman.
Yeah, there may be something needs to be made to the legislature just to ask them to investigate this matter and see if the legislation should be proposed, or we could propose legislation.
There's a lot of coordination that would have.
have.
Well, there's a lot of coordination would have to happen there, particularly between law enforcement and media, and that's a minefield,
Well,
especially for somebody that's neutral an agency that's neutral and trying to adjudicate these things.
I'm curious, and I'm not saying we do it for this case or whatever. I'm just curious what other states do. We can't be the first state or the only state dealing with body cam footage.
No, they're generally open. Generally open, which I think, there's a real, ironically, I guess in this case, the guy asked for body cam footage and 911 recording. There's a lot of analogies between those two types of records. And in a lot of states, maybe most states, 911 recordings are not exempt. So you might hear one from California where somebody is being murdered. They're dying and they're on the phone on the nightly news. Yeah. And I don't, as a policy matter, I personally don't think that's appropriate. So I don't necessarily think everything should be wide open. But just like with the bridge reports, I think there's a strong public policy argument to be made there that everybody's got a right to know whether the bridges are safe. Law enforcement are adopting body cams, as we said, to protect themselves primarily, but it also protects the public if a law enforcement officer. I used to be a prosecutor, prosecuted corrupt cops. Tony did that too. There's accountability that goes both ways there. And that's important. That's the whole purpose of them and the purpose of the Public Records Act. It's just when you're recording something that I don't know if digital video actually has frames like old film does, but if you think of it as frame to frame, if there's 1,000 frames in a short video, that's 1,000 separate public records. That's how complicated this is. And so I'm just not sure how you strike the right balance there. I wish somebody would figure that out and go to the legislature with a good solution, but that may have to be us.
Mr. Chairman, I got a question for
Sir.
the attorney brethren. Okay, so in your minds, what's the difference between the incident report and then investigative report? Is to help me to be able to say that, like it says, according to the statute, we're gonna read
2.2, paragraph 2.2, that's
with it
on.
not being an incident report, but focusing on investigating. So what's the difference?
I'll let our counsel explain that because I don't have the statute in front.
I'll tell you the city prosecutor level.
Sure,
And
sure.
the thing is, the instant report would be, Jane said Tom hit her and tried to run over their dog. That's the incident report. That would be public because she comes in and swears out a complaint and anybody can get a copy of that. What the officers then do in response, interviewing witnesses, taking photographs, drawing their own conclusions about what probably happened, that would be an investigation. And that's why body cam footage doesn't feel like an investigative report to me. But strictly speaking, it does fit into this definition that's in the statute.
I can see where my language of the body cam being a necessary tool for the law enforcement without showing their hand at first. I get that. I get that.
Also, this definition was drafted in 2008 and adopted in 2008. That was before body cams became widely used. I won't say they're ubiquitous. We've also had a couple of cases where somebody asked for body cam footage and there wasn't any because the officer didn't have body cameras. There was one where the officer was wearing a microphone that was connected to his dash camera. And they had already given the guy the dash cam footage. And he said, no, he was wearing a body cam. And they explained, no, that was a microphone for the dash cam. We don't have body cams. There's been other cases where the person thought the officer was wearing a body cam and the department didn't even own any. So there are a lot of expectations nowadays about body cams because of body cam footage people have seen, mostly on the internet, sometimes on the news. But not everybody, certainly in Mississippi, not everybody's wearing body cams yet.
Thank you.
Okay. I've lost. Did we adopt this?
Yes, Mr. Chairman, we're on item K now.
What? Yeah, we're on item K. Yeah. Okay.
Mr. Chairman, item K is our final public records case for today. This one I think is pretty straightforward and simple, hopefully more straightforward than body cam footage. This person asked for a lot of absentee voting records. and including absentee ballots, applications for absentee ballots, the envelopes that were mailed in, and a list of absentee voters. The election law says all of those documents have to be kept in a sealed ballot box. Everything that's in the ballot box is strictly exempt from the Public Records Act. There's only a couple of ways for anybody to get into a sealed ballot box, and there's a time limit on that. Basically, you got to be a candidate. You got to have standing as a candidate, and you've got to, I think there's a short window after the election when you go look at it, and after that, you have to go file something before you have to file an election contest. So sealed ballot boxes are sealed for good reason, and once something's in the ballot box, you can't just get it out on a public records request. So I'm recommending that this complaint be dismissed on that basis.
Okay, you heard the recommendation of staff, that this be dismissed. Is there any discussion? I thought. Hearing none, do I have a motion?
You can accept staff recommendation.
Is there a second?
Second.
Okay, motion made and seconded. We accept the staff's recommendation to dismiss this matter. Any further discussion? Hearing none, all in favor say aye.
Aye.
All opposed, no. The ayes have it. Let's go to the first, advisory opinion here, number L.
Yes, sir, Mr. Chairman. Item L is opinion number 25044. This one was presented last month and tabled, and I was asked to go get some more information, which is listed here. The question here is, and I thought this was very interesting for a number of reasons. I'd never gotten this question before. The county is self-insured for health insurance. From time to time, employees have a claim that is not covered. Maybe it's out of network or whatever. And according to the supplemental information, the county's insurance agent, they have a third-party administrator and they have an insurance agent. Those applications for a waiver, in other words, my claim wasn't covered. I'm an employee, my claim wasn't covered. Will you give me a waiver and cover it anyway? Those applications requests go to the insurance agent. He presents them to the Board of Supervisors. And to the best of the county attorney's knowledge, Board of Supervisors attorney's knowledge, they have always approved those. Well, now the covered individual is a member of the Board of Supervisors. So the question is, can the Board of Supervisors give a waiver to a member of the board and pay his claim that would not otherwise be covered? In my view, health insurance for supervisors is part of their compensation for serving in a public office. It's not a separate contract that they have an interest in, like a construction contract or a contract for the sale of goods or services or something like that. That is how I addressed the Section 109 issue. Under subsection 1051, this is part of their compensation provided for by law, also not like paying a claim or a contract or something. And so technically, I don't think it would violate 1051 if the supervisor voted on it. It would be like an alderman voting to raise his own pay. That's legal because it's compensation provided for by law. However, I think where it's only affecting one supervisor and not the whole board, it would create an appearance of impropriety if the supervisor votes to approve his own pending waiver. And so the upshot of this opinion is to advise them that to fully comply with the law, the supervisor should fully recuse himself from approving his own claim, but that the other members of the board are free to vote on it.
You've heard the recommendation of the staff here. Are there any questions of Tom or any discussion? Hearing none, is there a motion?
A motion to accept the proposed opinion.
Yes, is there a second?
Second.
Motion made and seconded that we approve the recommendation of the staff. Any further discussion? Hearing none, all in favor say aye. All opposed, no. The ayes have it. Let's go to item M.
Mr. Chairman, item M is opinion number 45. This was not presented last month. This is a new one. The facts here are interesting, and I had to go back and ask. This was requested by an attorney for this agency. I had to go back and ask the attorney some questions because the facts that were initially provided brought to mind multiple subsections of the prohibition section in section 105. And you can see here in the supplemental facts at the bottom of this page that the attorney responded to those, to my questions. One of the more troubling facts here is that this person, we're talking about a former employee of the state agency. While this person was still an employee of the agency, they submitted an application for this contract and apparently lied on the application and said, I'm not an employee of the agency. Well, somebody down the hall realized she was an employee, and they used the word terminated. The way I read this was, because she lied to us on this application, we fired her. After we fired her, she filled out another application for the same contract and submitted that. And so they're clearly not pleased with this former employee. I think, reading between the lines and being a long-term bureaucrat myself, I think they probably want us to be the bad guy and give them a reason to not give this person the contract. That's why I went back to them, because they didn't get on the front end, they didn't give us enough facts to say absolutely no, she can't have the contract. So I went back and asked some more questions. They still didn't give us enough facts to really say no. First of all, subsection 3E is the part that applies, part of the law that applies to former public servants. It says you can't be involved in something that you're personally or directly involved in while you were a state employee. They didn't give us any facts to believe that. And of course, this new application was submitted after she was fired. So she didn't have anything to do with processing that application. She didn't work there anymore. That takes 3A off the table. The other questions I asked were geared towards subsection 5, the non-public information section. If you have some information and you got that information through your government service and it's not public, and you share it with somebody, including yourself, who could make money off of it. I know it's really worded very complicated. I'm trying to simplify it and not do a very good job. If you share this non-public information with somebody and they could make money off of it, then you violate the ethics law. I always explain that to folks by saying, best thing to do is just keep your mouth shut. If it's not public, don't tell anybody about it. So there's reason to think that this person who basically worked next door, down the hall from the people who process these applications, might have some inside knowledge of the process that would give her a competitive advantage to get the contract instead of another applicant. That's what my questions were geared toward. They didn't give me a smoking gun. They basically said she might have some inside information. Well, might is not enough to say flat out no. But when you take the possibility of a violation of that subsection and add it to the public policy section that says we should all behave in a way that doesn't create public suspicion, there's a lot of smoke there. It doesn't really look good. And so my conclusion at the very end of this is that the potential for violation, an actual violation in the appearance of impropriety, could prompt the state agency to deny the application of this former employee. So I basically this draft puts the ball back in their court. They didn't give us enough to say no, but agencies can usually go further than the ethics law. They can have, for instance, personnel policies on moonlighting for things that aren't illegal under the ethics law. So I think that just sort of puts the onus back on them. I don't mean to kick the can or punt the ball or whatever, but that's just where we are with these facts, I think.
That's just what we did. That's what you did, yeah.
That's what
Okay.
the job ain't always fun, Mr.
You've
Chair.
heard the recommendation of the staff here. Are there any discussions or questions of Tom?
My only question, just a practical one, isn't an option not to render any opinion?
Yes.
Yes.
That's always
Yes, there is.
always an option. I don't feel comfortable that in this situation, because I feel like it might be misconstrued as us condoning the situation. In other words, the Ethics Commission didn't say you can't do it, or if the applicant gets wind of this, which is probably the point, Ethics Commission didn't say I can't do it, so you got to give me the contract. Under these circumstances, like I said, there's a lot of smoke here, and I think it might be more helpful for the commission to at least pump the brakes and warn somebody here of what could be a problem.
I'll completely follow your lead on that. I'm just thinking about a year from now or 4 years from now, if somebody uses this opinion to try to bootstrap himself or herself into an acceptable posture
Mhm.
on different facts. I know that's always an issue. but
It is.
that's on my mind.
It is, and it's very perceptive. I think we should always, all of us should always worry about that because we're required by law to publish these opinions. Once they're out there for all time. We have to live with them.
All the same, Mr. Chairman, I'm prepared with that motion if you're prepared here.
Question. Okay. If this person, if they had said, yes, this person had access to some things that were not public information and they could have used that for their benefit, would your answer would have been different, right?
I think the outcome would be about the same because you still have to sort of maybe not speculate, but at least you're left to warn the person if you do have this information, then you can't use it to your advantage.
Would you really are you giving this opinion to the state agency?
Yes.
And so if you were giving this opinion to the state agency and the state agency had told you, hey, this person had access to and does have confidential information, would you tell them, no, you shouldn't report it because of the potential for a violation? I mean, you say that those concerns could prompt.
Mm-hmm.
Would it be stronger if they had answered the questions a little
Yeah.
more?
I think I would have worded it more strongly. I'm not sure that I would have reached the ultimate conclusion that it's prohibited.
Okay.
Because there's at least two elements here. You got to have the information and you got to use it in an improper way. And
That would really require a case or investigation.
Yeah.
Or something.
Yeah, it really would.
Do you have any opinions that you're aware of where you've kind of given this, it could prompt the state agency? Is that similar to what you said in the past?
It's
not public.
It's
information?
very rare. I mean, it's always been my opinion that we should use the public policy section very judiciously because it's not enforceable. It's when we tell somebody basically, yeah, this is legal, but we don't think you should do it. And this is roughly, I think, in that category of opinion.
We have done that.
We have said, yeah, we have done that. We
We've
have also
done that.
said, no, you can't because of the public policy section, which is a stretch.
Yeah.
I don't think we can enforce it.
We couldn't, prove that. but-
Yeah, I mean, it's a
Yeah.
good illustration of the difference between an opinion and a complaint or an
Yeah,
investigation. This is advice. This is not enforcement. And they don't have to be consistent because it's two different processes.
But when the commissioners felt strong about that, they have used it. and
Yes.
Said, come after me.
Yeah, sometimes that's a matter of just
Yeah.
planting a flag and saying,
Yeah.
we think this is wrong and you shouldn't do it, or you can't do it, or it's so bad you can't do it. And I don't think there's anything wrong with that as long as it's done thoughtfully and judiciously and not, every opinion every month. That doesn't really help
You
folks.
just put this back into their hands. Yeah.
Sir?
You just put this back into their hands.
Yes, sir.
Yeah, okay.
I think that's about as far as we can go under the facts they've given us.
Any further discussion? Do we have a motion?
Mr. Chairman, I move we do approve the opinion as presented.
Second.
Motion made and seconded. We approve the opinion as written. Is there any further discussion? All in favor, say aye. All opposed, no. The ayes have it, been adopted. Okay. And you have one more.
You have the calendar. That's the next
Yeah,
item.
let's do, next is the calendar.
February meeting.
We're on February the 6th would be the next meeting. Normally, anybody have any thoughts or about that? If not, we'll just adopt February the 6th as the next meeting. Okay, and at this point, I need a motion that we go into executive session executive session to determine a need for executive session.
Mr. Chairman, I make a motion to determine whether the commission should declare an executive session.
Yes. Okay, look, going into executive session, we will do this in open session. Is there a need for a motion?
Mr. Chairman, I make a motion to enter executive session to discuss investigative proceedings regarding alleged violations of the ethics law, which are required by statute to be confidential.
Okay, is there a second?
Second.
A second. Okay, all in favor say aye.
Aye.
All opposed, no. We're now in executive session.
Thank you, Mr. Chairman. Let me.
Still on work. Rest for a bit. Long trip up, guys. Missed you downstairs.
This isn't some free will state, man. This is how it is in the state of Mississippi.